Good morning, Mr.
Buenos
Castillo.
días, señor Castillo. Buenos días.
Buenos días.
You're charged, you've got two very serious charges. Your first charge is burglar of a habitation. Your next charge is interference with the emergency request for assistance. The case that you are in front of me on here is the misdemeanor interference case. So it appears to me that the cases were filed on February 9th.
De febrero.
It looks like you were given a general order bond on that day.
En ese
We appointed you a lawyer on the 14th,
el día
so it's been a little less than a month.
menos de un mes.
What happened in this case? Because I have no
I
idea.
was going to say that, thinking about it since we're here and everything, can we hear PC? Because I think there's a good argument at least that I can come up with.
On February 8th, 2025, the officer was dispatched to a residence regarding a burglary alarm activated. The officer observed an unknown male wearing a black hoodie in the backyard of the residence, and the dispatch advised the resident was not home. The officer observed the male jump the back fence, and K-9 arrived and advised that forced entry had been made through the back door with shattered glass door. The upstairs of the residence appeared to rummage through, and officers located property later confirmed to be stolen from the residence, as well as a black hoodie, a black backpack, and a pair of pants. The K-9 located the defendant hiding, and the defendant admitted to being inside the residence during the time of the burglary, but would not provide further information. The complainant stated approximately $500,000 worth of jewelry was stolen, and a radio frequency device, jamming device, was located inside the black backpack, and it was
Oh, I remember
discovered that
this.
the officers within the vicinity were unable to use body-worn cameras.
This was on, I think, was this on, because of that radio jamming device, it was
Yes, Judge, the interference is based on the jamming device.
the interference with the emergency request for assistance is based on the jamming device that he has.
It has,
Interesting.
yes, that's what using the frequency jamming device to prevent communications between officers.
So it says here, February 8th, did then and there unlawfully, recklessly render unusable an electronic communications device that would otherwise have been used by Officer or by El Lejeune to request assistance in an emergency, namely burglary of a habitation, and said request for assistance would have been made to law enforcement agency, namely West University Police Department, who is using a radio frequency jamming device to prevent communication between officers. In this case, the device was actually used to disrupt communication, was it not?
The officer said that within the vicinity, they were unable to use body cams, key fobs, or unable to transmit information through the radio.
Got it. And we know, or I guess you're saying that he had the device on him.
It was in the black backpack that they found, that officers found, and they initially saw the male wearing the black backpack.
Mayor Judge, so two things. I don't know about the wearing the backpack part. I know they found the device in the backpack. My recollection might be off, but I don't think he had it on him. I don't think.
Well, he's got care, custody, control because it's right next to him.
That's the thing. I don't know where they found that. They said he was hiding, but I'm not sure where they found that backpack, first of all. Secondly, the way they figured out, hey, this is a jamming device, is because they turned it on from the backpack and they were close to it. Hey, all of a sudden my stuff's not working. Come here. Hey, we're close to it. It's not working. So this was after the fact that they figured out it's a jamming device. They didn't say, hey, jam this, we have this problem. They started playing with it and
They said he did.
no, that's the problem. He did not. They played with it. That's how they found out it's a jamming device. They turned it on, which comes up to.
Yes, they may have done that at that time, but also in the search, when they're looking,
During the active investigation, it was seen that their body worn cameras and their ability to unlock and lock police vehicles was affected during that active emergency investigation.
but they're saying it was used.
Right, they come back and say, hey, did we have trouble with it? Yeah, we had some trouble. They're turning it on and that's how they figured it out.
But you should be able to see all that. pull the records.
Right.
Because if they have body cam
Oh, yeah.
and they're using it, it should show a
It
disruption.
doesn't show that he was the one that it was actually turned on. They didn't show.
I know that, but you're gonna see the actual, you should.
Oh, yeah, yeah,
Disruption.
yeah.
I mean,
And he's not the only person that was involved in this allegedly. So saying that he's the one that turned it on is gonna be an issue. There was somebody else that was seen that they're not mentioning. So did he turn it on? Did the other person turn it on?
I mean, this news,
He's being charged.
is there someone else that was
Please look at
there?
the report, because I'm not just making this up.
And I'm not saying you're making it up, I'm just saying you did, it doesn't say that.
Which causing the question, why isn't it in the DIMS?
We have an OR.
Tenemos un reporte.
Does it say whether they were able to recover the $500,000?
They recovered it all, Judge.
They did?
Algo recogido.
The OR does say that Mr. Contreras admitted being inside the house with another unknown male and provided additional suspect information.
But no other male was on the scene.
They only found Mr. Contreras hiding at a property down a couple of blocks, I believe, from the canine officers found him hiding.
But the backpack is with him.
Yes. Well, the backpack was found,
At the front, it was found at the front of the residence located on Westchester Avenue, as well as see where they found him.
Versus with him. Big distinction. And the second person I'm talking about was supposedly seen on the surveillance video. So there's a mention of the surveillance video showing two people walking.
So to be clear, Your Honor, the property, including the backpack with the frequency jammer, was found on Westchester Avenue. Mr. Contreras was found hid underneath bushes at a residence on Rutgers Avenue. So it wasn't with him when they found it.
Versus what they initially said.
Inicialmente lo que ellos habían dicho.
Now we're getting more details.
Ahora ya tenemos más detalles.
How do you link him to the one who's using the device?
Eso, ¿cómo se determina lo que estamos hablando?
so the way that we would link him is that he was seen wearing the
Usando
the black hoodie, the black pants, and then later the same clothing along with the backpack with the jamming device inside of it, those are all found together.
lo hallaron juntos.
You say that was he wearing the backpack?
Initially, in the DIMS, it does not say that he's seen wearing the backpack, but his other clothing was found under the
Because the
backpack.
DM says he was wearing the black hoodie, and as she mentioned, the clothing, and jumping over the fence, they observed a male wearing the black hoodie, and they found that hoodie along with the backpack.
Junto con el backpack.
And they terminated their search after an extensive search of the mail, so they're unable to locate anyone else within the perimeter that they searched.
La búsqueda. Exacto.
There is surveillance with the second person there?
Yes.
Ah,
Yeah. It says
How do we know that the other person didn't use it?
¿Cómo sabemos que
I mean, I get it, that all of it's together.
Entiendo que todo esto.
We don't know who put that there. How do we know the other person didn't put it there? I know that he's wearing it, but
And Judge, this other case is still pending. This isn't
Eso está pendiente.
handling the
I don't care about the Berghab. My concern is this, is that, I mean, how do we link him to operation of the device? Why don't we do this? Why don't we have a full-blown hearing?
Yes,
Look through, you know, go through everything. You go through everything. We can have it tomorrow.
Mañana.
See what you can, you know.
I think that's the correct position, so we can have both of us.
I'm not opposed to finding no PC. right? I want to know if you can truly link them or not. You know, I'll give you a day, come back tomorrow and see what else you have. If you have nothing else, then we'll go from there.
I appreciate that.
Sure.
Full-blown hearing for PC. They could
Take
always
a look, please. We'll give everything that you have access to, give it to counsel so he can take a look as well. You can take a look at any kind of videos, you know, take a look and we'll see.
Así está bien.
I mean, all we have now,
Encontramos ahorita es de que
he's wearing
él está usando
a hoodie, he's wearing pants.
And then they found the
y
clothing with
dieron
the
la
back.
ropa con el
Judge, they could always refile
Entonces
this.
podemos
They don't have to
darlo de
dismiss it.
vuelta, no
They-
tienen que
They could always
cancelarlo,
refile.
pueden
Even
archivarlo de
if-
vuelta. Eso sí,
You're
pero
springing it, I mean,
Not springing it, this is no OR.
I'm gonna give them a day.
Okay.
I mean, he's not going anywhere anyways.
no
Okay,
quieren
fair enough.
arreglarlo
Let the bird have
como quiera.
upstairs. He's stuck here regardless. So I want to make the right decision. So
Fair enough, Judge, fair enough.
Decisión correcta. This one is in
Is there a certain time you want the hearing?
whenever you want.
Okay, sounds good. Appreciate it, Judge. Thank you.
Está con la base.
Judge, may I read your approach on that, Mr. Castillo?
On who?
The hearing tomorrow, Mr. Ignacio Castillo.
Okay.
Judge, just to be honest with you, I'm a little confused as to what kind of hearing it is tomorrow, but the more I think about it, it's like if it's an actual hearing on the record and we're trying to figure out what's going on, I mean, do I have a right to subpoena some of these people to come and testify regarding this or
Well,
what?
then if you're gonna start subpoenaing people, I have to give them 2 weeks.
Right, we're gonna have a hearing on the
I was
record.
just gonna, you know, if there's video, they're saying surveillance and make sure that there is another person there that, because
Using the minutes in the offense report, which are those sworn statements, would be enough to establish probable cause. So I don't think we need to subpoena anybody to be here.
Which we've already done right now, so I don't understand what the hearing for tomorrow is gonna be different.
I think more to the point, we just need time to further review the OR. So tomorrow, because it is 8 pages and there's a lot more details that we need just some time to review, just to further determine whether probable cause. So just tomorrow, we can revisit this and we have a full understanding of the OR.
Okay, so we would be hearing stuff, but I don't have a right
we're
to.
just, I'm giving them a little bit of time until tomorrow. That's
Okay.
Ricardo.
Okay, I'm just thrown off when we still talk about hearings. It's like, okay, are we gonna be on the record? What are we doing?
I hadn't planned on it. If you want it on the record, we can.
Can I talk to Richard, see if we could work this out? Right, I mean, because, like, if we're gonna roll it, I mean, I want to subpoena some people.
Leave today, give him I need to look at this more. It's kind of the first I'm seeing of it. If we, I'm not in a position to complete it today, just give him.
No, not complete it. I mean, just look at it, see if you think you have probable cause to.
Okay, I mean.
If that's what we're
You guys
asking for,
talk.
let's talk about it. Let's talk about it.
I gotta roll, Ricardo.
Yeah.
Oh, okay.
I gotta go. Can't just sit here and wait.
Well, if that's the case,
An hour,
if that's
45
the case,
minutes.
can we set it for a real hearing and I'll subpoena people 2 weeks out? Let's do that.
Oh, okay.
Okay.
Let's pick a day. Let's pick a day.
Sure.
Let's see. Ignacio Castillo, CAS.
Bond conditions.
Let's do, we are at the 12th.
They were getting filed, so you know when to come in? Okay.
Yeah, I'll subpoena them.
That's it though, right? That's it? Okay.
Can we do the 28th?
Whatever day you want. Oh, any day but
27th, I'm sorry, I got the wrong one.
That's the next one that we.
Oh.
Stella, come up. Sir, you were charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 6 days in jail with credit for the 2 days that you've done. You need to understand something very important, that this will go on your record as of today, and it's going to be there for the rest of your life. You can never take this off. From now on, you'll be facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand? So you give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So there's no turning back. Once you plead guilty, it's on there forever. Is this what you want to do? How do you plead to the offense? I'm going to find you guilty. Was it a gun?
Yes, Judge. the firearm.
The weapon will now be forfeited to the state. You will not get it back. Do you understand?
That was fast, 6 days in jail and his weapon gone for good. But notice how the judge hammered the point about this charge staying on his record forever. That's not just courtroom talk, it's life-changing. What do you think? Was that deal fair or too harsh for a first offense?
Okay, good luck to you, sir. Or how do you plead?
Guilty.
I'll find you guilty, sentence you to it. Good luck to you, sir. Thank you, Josh.
Question?
You can run it. Good morning, Ms. Rodriguez. Ma'am, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 4th, 2025, the officer was dispatched to a minor accident at 1700 block and is arrived to serve county detective. The officer made contact with a witness who stated she heard and saw the defendant with a cyber assault on the vehicle, sideswiped a parked motor vehicle. The officer noted the vehicle was parked incorrectly facing the opposite way. The witness stated she believes the defendant is intoxicated, and the defendant stated she hit the motor vehicle while driving as she took her eyes off the road when trying to retrieve her cell phone, which fell to the floor. The defendant stated she remained on scene because she wanted to make it right with the owner. The officer observed slurred speech and swaying, and the defendant admitted to having drinks earlier in the day. Standard field sobriety tests were conducted and the HGN test began, however, was suspended at the defendant's request due to high winds. The defendant was placed under arrest for suspicion of DWI and was transported to the jail. Standard field sobriety tests were then conducted at the jail. HGN 6 out of 6, walking turn 7 out of 8, one leg stand 3 out of 4. The defendant was read DIC and consented to provide breath. The first sample came back deficient and the second sample came back unacceptable. A blood search warrant was signed and executed.
Well, ma'am, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. You will be randomly tested. If I find that you're consuming alcohol or
This is where it gets real, the interlock device. Basically, she can't even start her car unless she passes a breath test. It's one of the toughest DWI bond conditions out there. But the judge seems firm yet respectful here. Notice how he praises her lawyer. Think that compassion helps or hurts defendants long term?
illegal drugs, your bond will be revoked. You'll go into custody. I'm also now placing a restriction on your license. You're not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, then likewise you will go to jail. We send notice to DPS of this restriction and this requirement so that if you're caught driving a vehicle, it doesn't matter where it is. Every officer in this state will know that you're required to have an interlock. So if you're caught driving a vehicle, they will arrest you. You've got a great lawyer here. Listen to him. He'll take care of you. Because you have him, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him. He'll tell you when you have to come back to court. For now,
She's already had the interlock installed.
wonderful. Okay, so you're just not much of anything. Just stay in contact with him. He'll tell you what to do. We'll just have you sign a reset and then you're on your way. Okay, thanks.
Good morning.
Hi. Who is
I
it?
tried to call the holdover judge, but I don't know if I have the right number. 2689, is that right?
What number can he call over to talk to someone?
Which should have been in this.
Who is it?
Oh, it's on, let me get to him. Sorry. It's a brand new one. He's got 2 cases out of Louisiana. It starts with an S. It is.
Oh, I thought he refused, right?
No, he refused. So I guess we got to bring him out anyway.
Yes, get the packet.
But it's 3199.
3199, Greg.
3199.
Yeah. And then he's a refusal from yesterday, or from, I think it was yesterday.
Okay, I just got appointed today on it. Do you want me to call first and then just come back on?
So yeah, just to give you a brief heads up, he's on probation for an evading in a motor vehicle upstairs, 42nd,
So he's got a
From-
local.
23, 310, he picks up an assault, a failure to ID as a fugitive, and now we have this fugitive case.
Okay, so he's got locals. He's probably not going to sign anything.
He has not made bond on the assault. He has not made bond on the probation, so it looks like we're kind of in a holding pattern for those two, by the way. So
Do we know the court date on this?
let me see.
On the evading judge, it's.
Tomorrow in the evading. Or the
So
second.
you want me to just talk to him and then we roll him to Friday?
It's up to you. You talk to him, see what you want to do, whether he wants to keep the refusal, whether he wants to, whatever he wants to do. And then
Okay,
just let
well,
me know
if he's not
if
gonna
he
make
wants to get
bond
a
on the
bond, whether
local.
he wants to waive, whatever he wants.
Okay, if he's not gonna make bond on the locals, but if he insists on asking for a bond.
Right, I will let you know, there is a pre-signed waiver on the
Oh, pre-signed waiver.
Oh, there is a pre-signed waiver.
Oh, I can't give him a bond.
Okay, let me see if he's gonna keep that pre-signed waiver. And I'll jump back on.
No. That's not, once there's a pre-signed waiver, that's it. You've already waived. You waive by signing that agreement, whatever agreement you sign.
So, but you're saying
Louisiana,
he signed a pre-signed waiver of extradition, so there's nothing for me to really do except track.
Correct. Right. Just advise them we're in a holding pattern until you take care of all the locals. And at that point, once all the holds have been lifted, that point, we give Louisiana up to 30 days to come get you.
Okay.
So also note, if we're gonna go for a kind of waiver, in that central agreement, the public today, that one can sign the 14-day waiver.
Okay.
So from the pre-signed waiver date, then I should just keep the 15-day reset and see if anything happens, great. If nothing happens on the locals, then whatever. See what I'm saying?
Yeah, so if he wants to waive today, just let us know and we'll write it up.
Okay, and what would that reset date be?
It's gonna be a reset to track locals, so it looks like he has his
So
next.
it'd be Friday anyway.
Well, he also has an ABI on the 17th and he has a big bond on.
So, yeah, the failure to ID, both of those are in court too. They're set for, one's set for yesterday, one is set for the 17th. So we could probably, the 18th?
18th? Okay.
Yeah.
Let me,
3199.
yeah, thanks. I'll talk to him right now. Thank you, Judge.
Let me know when you're ready. You were charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On July 5th, 2022, the complainant told officers that the defendant was terminated for intoxication and attendance issues. The complainant believed that it was clear to the defendant was not to return to the physical location of the business. The defendant returned a few weeks later requesting money from an employee, spoke with a manager to say his termination was not fair, and the defendant approached employees while they were on break, and employees stated the defendant was making them feel uncomfortable. The complainant told the defendant not to come back to the property, and the defendant stated he understood. Approximately a week later, the complainant was walking to his vehicle in the parking lot at the location and saw the defendant inside his vehicle. The defendant had snapped the side view mirrors off the vehicle.
So just a trespass, no.
Just try to.
All right, Mr. Wood, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go back to this location. Do you understand? If I find that you violate conditions, if you pick up a new case, I will revoke the bond, put you in jail. No more PR bonds for you. Your bond amount is set at $100 now. So he has not made bond, right? Okay. I will give you a PR bond today, Mr. Clark. I'm sorry, Mr. Wood, but I'm not going to give you another one. If I find that you're a danger to my city in any way, I don't care. I have a place for you. Do you understand?
Yes, sir.
So for now, what I'll have you do is, do you have a lawyer today?
I do not, Your Honor.
Do you have the ability to hire a lawyer?
Do not, Your Honor.
Okay, I can have you fill out an application for a court-appointed lawyer. I'll take a look to see whether you qualify. I need to know everything about you. How much money you have in the bank, what you do for a living, any source of income, what kind of car you drive, money in the bank, stocks, bonds, IRAs, mutual funds, anything.
Got documentation.
Okay, well, no, I need you to fill out my application.
Yes, sir.
And then I'll have you sign a receipt with Victoria. We'll have you take your seat in the jury box. Do not leave until you sign our bond conditions, okay?
Yes, sir.
Okay, come on. So can you file, no, going back to this location, please? No weapons.
As well?
Yeah.
Yeah.
Good morning, Miss Lynn. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, sir.
Yes, Judge. On March 9th, 2025, at approximately 11:29 p.m., the officer was dispatched to a wrong-way driver call at 1623 South US 59 Freeway in Harris County, Texas. Upon arrival, the officer observed a vehicle stopped in a moving lane of traffic with multiple tow trucks around the vehicle in an attempt to box the defendant in. The defendant's vehicle ignition was on and the vehicle was in park. The officer made contact with a real witness who stated they saw the defendant's vehicle traveling southbound on the northbound side of South US 59 and that he and other tow truck drivers boxed into the defendant's vehicle at 4800 Main Street. The officer observed the defendant to have an odor of an alcoholic beverage, swaying and stumbling. Bloodshot eyes and disorientation were also observed. The defendant admitted to drinking 6 drinks at the Houston rodeo and stated she was 4 out of 10 drunk. The defendant refused standard field sobriety tests. The defendant was read to DIC, and the defendant refused to provide a specimen. A blood search warrant was signed and executed.
You can look her up to see if she has any prior DWIs. Number
She
one.
doesn't. She has no prior. Everyone is eligible.
Okay, Ms. Lynn, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Now you have a lawyer. They will take care of you. I will waive your appearance because you have a lawyer, but it is your responsibility to stay in touch with them. If they tell me you've gone AWOL, you pick up a new case, become a danger to my community, I only have one place for you. Do you understand, ma'am? Okay. We'll have you sign a reset with Victoria. You'll get with Fleischer for your bond conditions, and after that, you're free to go. Okay? Thanks.
Couldn't get here. And actually, Judge, I got a 2-year-old I'm running behind, but I'm approaching today, Judge, on this case. We did file. I got some emails and check stubs that we attached to the case because I'm pleading, my client has basically lost his job because you put an ankle monitor on him to where he cannot go out at night and he has to stay home for this type of offense. And it's a resisting arrest. Let me refresh your memory. I know you've had 1,000.
No, I remember.
Right. And so I didn't know all of this when a case comes in, the day before. I don't know.
Is this the one where he stomps on the person's head and the person's unconscious and then?
And so what I did was, I told you, I said, Judge, there's a before, in between. We don't know, but we do know, as we all know, what happens at intake. Even when I was intake, there's a reason they declined charges. I believe Madam Prosecutor got up and said it was because he was unconscious, and you and I both know they would still accept charges, even if not for him. So I'm assuming.
I've seen crazier things. I mean, we had it the other day where a guy gets run over by a bike and they filed nothing on that,
I get
So,
it, Judge.
I
I guess my whole thing is bond is to secure them coming to court. What we don't know, Judge, and I believe on video on Friday, what I saw was I heard a dim summary, and it's almost as though in my humble opinion, I believe the restrictions that are put on him are just too egregious. It's almost like we're convicting him of a crime. First off, that wasn't charged, and then 2, that wasn't even filed.
My thing is like, I don't want him to go out to bars. I don't want him to go out drinking. And so that's why I don't want him out in the middle of the night. So he's not going out and doing things that he
You
shouldn't
can do that in the day, Judge. I'm with you.
I get it.
No, and I said on video, I said, Judge, I said, after reading the news, I'm in both seats too. And so, yeah, it does, but he's now lost
It's
his
less
job.
likely to happen in the day than in the middle of the night for the
Like, hey,
shenanigans.
Judge, but we can say that he works. And literally.
I told you, if you show me that he works in the middle of the night.
Now this is classic courtroom tug of war. Defense wants leniency for work and family. The judge wants control to protect the community. Both sides have a point. But here's the question for you. Should strict nighttime restrictions stay when someone's just accused, not convicted yet?
I will.
I actually was with it. His boss.
I told you, I'm okay with it.
Yes, sir.
I will have a GPS monitor on him, so I know if he's deviating from where he's supposed to go.
No problem.
If he's going out somewhere else, because the only reason I will let him out is for work purposes only in the middle of the night.
What if he has to go get Pampers for his baby? What if he
He can do that during the day,
Well, I get it, Judge. I'm just saying.
at 3 a.m.
I don't disagree. I'm just saying, I don't want the restrictions to be so tight to where if he stops for gas, then they're like, oh, he stopped at the gas station and he got gas.
Why can't you anticipate these things doing it
Well,
during
no,
the
I
day?
mean, Judge, everybody don't think the same. I'm just making sure that if I don't agree with if you want to do the ankle punches, that's fine. I'm just saying, Judge, I think for this type of offense that we don't have assault charges for resisting, to me, it's a bit egregious.
They're telling me that they're going to file the assault charge.
It happened today, Wednesday. I checked Monday, that's why I didn't come in on Monday, because I was waiting.
Please?
And, and here's another issue with that, Judge, is because of what happened on Friday, I got some
Really?
other stuff.
I'm acquiescing to your thing.
So we're looking
I'm
at each other.
saying yes. I just want him to go to work.
Yes, sir.
That's it. I don't want him going anywhere else.
Yes, sir.
If he needs to get gas, if he needs to get groceries, this doesn't need to happen at 3 a.m.
Understood.
Do it during the day. That's it.
Understood. Yes, sir.
I'm okay with him going to work in the middle of the night, but you need to let him know. I've got a monitor on him. I know where he's going.
Yes, sir.
If he deviates, I'm going to revoke his bond.
Yes, sir. For work, he also, when he goes to work, he works dealing with oil or something from my understanding. And so he does have to drive. I just want to make sure that if they were to say, oh, it looks like he's driving once he gets to work, it's because of the nature of his job. And we can bring proof, hey, this was what he had to do today.
Great, but if I find that he's at Club Punka City,
Yes, sir.
at 3 a.m, I'm going to have an issue.
I understand. Yes, sir. I understand. I get
Okay.
it.
So
Before decision is made on those charges, I wanted to reach out to the complainant and get that correct. That's one of the delays. I'm just finding out about this.
Yes.
I mean, it's pretty egregious, and I placed a restriction on so that he wouldn't go out, do anything he's not supposed to do in the middle of the night. I told him not to go to any bars, clubs, any places of this nature. And if I find that he does, and what she's saying is that he works in the middle of the night.
He said it on Friday too. He actually had a check stub to show you that day, but I wasn't here.
I'm not gonna look, I'm not gonna.
I wasn't here, so that's why,
Just let him know what the conditions are.
Yes, sir.
And that's it.
Yes, sir. So do I need to get an amended from her?
Right.
Yes, sir.
Yeah, and I'll waive the signature so he doesn't have to come down here, but
Yes, sir.
he's gonna have to, just let him know.
I will.
If I find that he's shenanigans, it's just not gonna go.
I understand, Judge. I definitely understand. Thank y'all. I appreciate it. Thank you. I'll be in touch.